When modern people think of law, we think of something contained in a codified text. This is something we call statutory law. It's not necessarily made up exclusively of statutes, that is, laws passed by a legislature, but it's a combination of statutes, regulations, and proclamations, plus court rulings about these statutes, regulations, and proclamations. So statutory law is a legal system in which the source of what is the law is written codes. What is written in the code is the law. And this written collection of statutes and regulations supersedes custom. What determines what is legal is not custom, how we've done things around here for generations, but what the written law says. Because of this, courts pay great attention to the wording of the text, the written law, and they cite the text in their judicial decisions. And when there's no explicit legislation on the matter at hand, judges extrapolate from written laws dealing with other matters to ascertain what the law is in this matter. For us, this understanding of law is intuitive and commonsensical. We have a hard time imagining another rational system of being governed by the law. But until not too long ago, the early 19th century, the vast majority of Germans, Englishmen, and Americans did understand law differently, within a system and a mindset of what is called common law. In this view of what law is, a judge based his decision not simply on a written body of statutes and regulations that he applied to the particular case brought before him, but also on the habits and customs of his community as documented in previous court rulings. The result was that in a common law system, legal norms developed gradually by continual restatement and refinement and distillation of previous court rulings. Judges were empowered to modify legal norms incrementally, but were expected to do so within the framework established by previous judicial decisions. This allowed the law to change, but not as radically and rapidly as the law changes when a legislature passes a new statute or when a king issues a new regulation or edict. For example, our legislature, which is Congress, can pass a law today drafting all of us into the army. And tomorrow it can pass another law, another statute, to undo today's draft law. So with statutory laws, legislatures can change the status of the law completely and abruptly. By contrast, in a common law setting, judges can adjust the law to fit the customs and circumstances of a community, but only within the framework established by previous judges and judgments. Also, in common law systems, a judge's decision itself does not create a binding precedent. A future judge can arrive at a different decision when adjudicating a future case, though again, judges are expected to do so within the framework of previous judges and judgments. Okay? When common law judicial decisions are collected and published, this text does not itself become the definition of what the law is. The fact that decisions were written down does not make them the law. They are instead a resource of argumentation and reasoning for later jurists to consult as they argue and adjudicate their own cases. They are a reference tool from which a lawyer or a judge can pick legal arguments. Now, common law systems reflected demographically stable and homogeneous communities. Social homogeneity and stability produced a wide and stable general agreement in a community about what our common values and common interests are. These communities shared a common language, religion, and history, common economic circumstances, and common enemies. In this context, most societal norms did not have to be legislated or written down, since they were not much contested. People got the message of what attitudes and behaviors were expected of them, what was legal and illegal, by daily interactions with family and neighbors. But when demographic growth and geographic mobility broke down this homogeneity and cohesion, when communities featured different religions, different traditions, different physical circumstances, economic opportunities, and different economic interests, then the agreement about what was right and wrong and legal and illegal broke down. Basically, this kind of diversity within a community made it difficult to base the law on a common set of customs and values, simply because this large variegated community now featured different sets of customs and values and interests. And the Industrial Revolution brought about exactly this kind of growth and diversity to English and American communities, especially in rapidly growing urban centers. Common law, which reflected communal consensus about ethics, could not serve such a large heterogeneous population effectively. So instead, sets of rules were increasingly formulated, legislated, written down, published, and disseminated to create and enforce a behavioral standard among all these different constituents who came from different backgrounds and held different values and ethics and beliefs and interests. Thus, by the late 19th century, legal codes, that is, statutory law, started to crowd out or wholly displace common law in most of the Western world. So, in summation, common law was a way for consensus-driven communities to govern themselves. Statutory law grew gradually in Europe and America as these communities began to grow into communities that did not share such an ethical consensus. The result of this transition is that today we govern ourselves mostly through statutory law, even though we still see traces of the old common law. Just as we primarily live in large, diverse cities and suburbs, but still see traces of communities like Mayberry and Walnut Hill. By the way, for those of you who don't get the reference, do yourselves a favor and watch a few episodes of The Andy Griffith Show and Little House on the Prairie. In any case, the point is that for us, codified law, statutory law, is the law, whereas common law operates on the margins. But when we study the 17th and 18th centuries, we need to remember that the situation was reversed. Back then, it was common law that commanded greater respect and deference from constituents, from local officials, and from local judges and juries. Okay. By comparison, statutory law held limited sway and legitimacy and credibility in early modern England and America.